Running a business or being a business leader brings with itself a lot of challenges. The Leading to Win podcast will help provide our clients and business leaders with knowledge to help them make wise business decisions by leading to win. Here is your host, Marty Haynes. Welcome and thank you for listening to Leading to Win. I'm Marty Haynes, and Leading to Win is to give leaders the right information in order to be successful in business. So that's our goal and what we're going to do here today, because we've got a great topic and we have a great guest today. And we have Joanie Winters with us. She is from Winters Law Firm. And Joanie, thank you for joining us today. And if you would, because I've known you a good while here, give our audience a good idea of where you've come from professionally, you know, where you were at one point and where you are today, and kind of where your experience has come from.
Okay, and thank you for having me, Marty. It's a pleasure. I really have a diverse background. My husband and I had a manufacturing operation at one point in our lives in Trinidad in the West Indies. We sold the business and I went to work for a construction company in suburban Philadelphia. And while I was working there, I really developed an affinity for human resources. I just really wanted to be a human resources professional. Didn't have a degree or anything like that. And when we let the HR director go, I went to my boss, who was the CFO, and said, I want that job. He said, you can't have it. You don't have a degree. And he was a little bit of a curmudgeon. He came out later and said, okay, go get the degree. We'll pay for it and you can have the job, but we'll review you in 6 months. And so I did the job for 10 years, got my degree at night. Halfway through my degree, I realized I really was developing an additional affinity for the law. My husband got transferred in the meantime to South Carolina, and we got here and I said to him, I want to go to law school. And my husband, who is ever indulgent in my whims, said, sure, whatever. Mm-hmm. And so I went to law school and graduated at the age of 40. No, actually, I was 45 when I graduated. And so this is a second career for me. The primary focus on our practice is human resources, employment, labor, just because of my background. It's what I know. And so when we work with a client, I've sat in their seat. I know what they do. I know the pressures they have. So the bulk of our practice is employment law. We focus on that for management only. We don't represent individuals, only companies. And we've been doing it now for, I'm proud to say, 20 years. And we have clients all over the state, some out of state, because most employment laws are federal. And so that's in a nutshell. That's how I've gotten here today.
Okay, well, good. That is a good bit of history there. Now, the main topic today, and this is one of these things that can kind of scare people, and the topic today is the monster you didn't prepare for, and that is the EEOC. You know, you start mentioning some of those things, you know, it makes the hair stand up in the back of your neck, those sorts of things. What is the EEOC?
The EEOC is the Equal Employment Opportunity Commission, and they were created in 1964. They're a federal agency. And I can tell you the title of that is sort of a misnomer, the monster you weren't prepared for. I've worked with the EEOC folks. They're really nice people, but they adjudicate the law. And the law that they are assigned to adjudicate is called Title VII. Title VII is a section of the Civil Rights Act of 1964, and it is the bundle of discrimination laws that says to employers, you cannot discriminate based on certain inherent characteristics. And so EEOC was created in 1964 to enforce those laws. They also have what's called state deferral agencies, because they have a lot of charges of discrimination, unfortunately, still in the year 2020. And so these state deferral agencies, if they exist, they can be assigned charges of discrimination in the interest of getting them adjudicated quickly.
Okay. And in that, what are some of the protected classes? What are we looking for?
Okay, protected classes include race, color, sex, religion, disability, national origin. And just recently, we had a Supreme Court ruling that protects the LGBTQ community under the protected class of sex. We also protect genetic information.
Mm-hmm. Okay.
classes.
What are, sometimes just in people's ignorance, they may say something, do something. What are some of the discriminatory practices? What are some of the examples that we could see?
We may fail to promote someone because they are a female, because they are disabled. We may not hire someone based on those protected classes as well. So any of your employment practices, hiring, firing, promoting, even giving raises, things like that. So if we don't treat everyone equally, there could be a basis for discrimination.
Yeah. Okay. Well, some of those. I mean, I think you mentioned some of those. Sexual harassment. Sexual harassment is what it is. But sometimes people say things, again, in ignorance, or it was the way they were raised, or some of those things. Sexual harassment. Give us some idea of what we're looking at.
Okay. So the legal definition of sexual harassment is unwelcome conduct based on your gender, based on your sex. So if I have pinups, I'm a female, but I have pinups of male bodybuilders, and you're offended by that, and you ask me to take them down, and I say, I'm not taking them down, Marty, I like them. Mm-hmm. That could be unwelcome conduct against you, and I've refused to take them down. It could be deemed sexual harassment. Sexual harassment is not just against a female. It could go either way. And with LGBTQ community now protected under Title VII, it's also same-sex discrimination or harassment.
Okay. All right. And I know we've gone through some things like, 9/11 and some different events in our country. What about national origin discrimination?
That's a great question. We're seeing a rise of that since September the 11th. Tomorrow's the anniversary of that horrific event. And so if you hearken back to Pearl Harbor, right after Pearl Harbor, there was horrible, horrible discrimination against anyone who was Asian because of what happened that day at Pearl Harbor. Right after 9/11, there was a great rise in discrimination for Middle Eastern folks, and some of these people are American. That's their descent, their national origin, and so we have seen a rise in national origin discrimination since September the 11th based on that.
Yeah. Now, that being said, I'm assuming there's a difference between national origin discrimination and race and color.
There is. National origin discrimination is based on your family history. Where have you come from? What country have you come from? And you could probably do a dotted line on national origin to if you're of African descent. Certainly, if you're from Nairobi and you come here and you're discriminated against, you could legitimately have an argument that you because of your national origin, because of your race. Color is a completely different story. There's no true definition under Title VII for what designates color. We've had only a few claims here in my office where we've defended employers on those, and it's typically where you have two African Americans, one's light-skinned, one's dark-skinned, and they're saying that they were discriminated against, not because of race, because they're of the same race, but because they're of different color.
Okay. Interesting. Didn't realize that. And since we're on national origin, sometimes you get into some religious aspects, religious discrimination, whether it's there or just, here. And when you describe that, you gave an example one time, and I got educated, the religion about the hair.
Yeah. When we think of religious discrimination, most of the time we think of not providing an accommodation for someone who doesn't want to work on a Sunday or a Saturday because that's their faith day when they go pray or whatever. But we have to be careful with our appearance policies as employers, because if we're telling folks you have to be clean shaven at all times, well, there are religions that require the growing of a beard for the male who is practicing that particular religion. And so to have a policy that has zero tolerance for no beards, it could be religious discrimination. And I can tell you that UPS just recently got themselves into some litigation because they had a zero tolerance policy for facial hair. And they were sued by a group of Muslim men who said that that's religious discrimination. That's part of our religion. And so now, surprisingly, you will see UPS drivers with beards, which you've never seen in the past. It's religious discrimination.
Now, what was the one where the guy had long hair, right? You called it something, and
Yes, he that was Publix supermarkets. It's a published case, and a gentleman was hired for the deli counter. And at the time he was hired, he had dreadlocks. The HR people saw his dreadlocks. So he shows up for work. His first day, he's excited. And the deli manager says, that hair's got to go. You have to cut that hair. And the gentleman said, no, I'm Rastafarian. It's part of my religion. And it really goes back to Samson, where Rastafarians believe that's their strength. And the deli counter manager said, if you don't cut them, you are fired. And the gentleman walked off the job because he was not going to cut his hair, filed a lawsuit against Publix. And his primary argument was, first of all, they're part of my religion. But secondly, and most importantly, everybody behind that deli counter had a net on. There were women who had longer hair than he did, and they had hair nets on. So why couldn't he have the same accommodation of the hair net? And great question. He was clearly discriminated against because of his hair.
okay, yes, I learned that was a bit of education for me. Pregnancy.
Pregnancy is covered under the protected class of sex. And so we cannot discriminate against women who are pregnant, but that doesn't mean we have to treat them differently. There aren't special rules for pregnant women, but if we fail to hire someone who's clearly pregnant, we've discriminated against that person. Just like if we fail to hire somebody who's clearly disabled, we would be discriminating against them because of their disability. So pregnancy is a temporary disability, but it is still protected under Title VII that we have to, I've often said, Marty, if we could take a screen and bring it down so we couldn't see that person's color, national origin, physical presence, whether they're pregnant or disabled, and hire or make employment decisions with that screen down, then the chance of discrimination would be slim to none. So he is covered under the protected class of sex.
Okay. Now here's one that I fell into. I'm 51 now, and I fell into it at the age of 40, and I had no idea I was officially in that category. I didn't think I was in that category at 51, but I guess I am. Age discrimination.
Yes, sir. Age discrimination is an amendment to Title VII. It protects those who are 40 and over, 40, not even 50. Started out at age 70 when the bill was first passed in 1962, and ultimately ratcheted down to the age of 40. And age discrimination is the only protected class that does not have a reverse discrimination piece. So I can't file a lawsuit saying that Marty was hired because he's 51 and I wasn't hired because I'm 22. There's no reverse discrimination on that. But yeah, we see a lot of age discrimination cases.
Okay. Now this next one, I've often had questions about it and didn't fully understand where they got their number, but the Equal Pay Act, is that something that you look at, if you're, if you got a male, female, same qualifications, experience, everything, that you have to pay them the same amount? Or, because sometimes you hear on the news about a discrepancy in pay, say between male and female, and historically, when there are children involved, historically women may decide to stay home for a period of time. Do they, and generally the guy, generally speaking, will stay employed full time? Do they take that figure, and are they averaging, okay, historically over a period of time, there's no work in this particular time frame, and they're averaging numbers and coming up with those types of formulas? Or are they basing this solely off the idea that you got two qualified individuals, the only difference between is their gender, and you're paying one gender less because they're that gender?
And that's part of the analysis that the EEOC will go through. Again, there's that screen. If it were to come down and you couldn't see those genders, that's where the equal pay might come into play. This is something that's been a problem for years and was recently reformed under the Obama administration to be called the Equal Pay Act, or excuse me, to be called the Fair Pay Act. It used to be called Equal Pay Act. And that came about from a woman by the name of Lily Ledbetter, who worked for Goodyear Tire for 30 years. And on her retirement day, she got an anonymous note that said for 30 years she had been paid much less than all of the men on the production line on which she worked. And so Miss Ledbetter filed a lawsuit and was successful at the first blush. And then Goodyear did file an appeal. They were successful. And then President Obama actually created the Fair Pay Act that said that you can reach back 30 years if you have to show that you've been paid disproportionately against what's called similarly situated employees. And I think that's your point, Marty. The court will do an analysis, or the EEOC will do an analysis of, are these individuals really similarly situated? Forget that you took time off for childbearing, but do you have the same credentials as the other individuals? So it's a balancing act for the EEOC to try to determine that. They're hard cases, very hard.
Yeah. Okay. Now, being a business owner, I can look out my window and I can see a ramp that was put up. And I'm assuming when they built this building and when they did this, or maybe after the fact, it's because of the American with Disabilities Act.
Yes, sir. That was 1991. That was an amendment to Title VII as well that brought disability into the protected class list. And so if any qualified individual with a disability who can perform the essential functions of the job with or without a reasonable accommodation falls under the ADA. And so lots of landmines in that one sentence. The individual has to be qualified. So if you are disabled but not qualified, you're not protected by ADA. So you have to be qualified, and you have to be able to perform the job with or without a reasonable accommodation. So if you are hiring a receptionist and she is in a wheelchair, she is permanently in that wheelchair, or even temporarily, and she can't get up a flight of steps, well, you do have a ramp out front, so you can reasonably accommodate. If you were on the third floor and that individual in the wheelchair, her job was on that third floor and you didn't have an elevator, a reasonable accommodation is not to ask Marty Haynes to put an elevator in that building. Mm-hmm. So the EEOC will analyze what's the cost factor, what's the disruption to the business, what's the size of the business, and is there a reasonable accommodation available that works for both sides.
Okay, interesting. Now, considering the times that we are in, my question to you is, does the Family First Coronavirus Response Act fall into any of this EEOC?
That's a great question. And lately I feel like all we've talked about is coronavirus. So I was really glad you picked a different topic, but it's still relevant. Coronavirus, I think, is going to affect us in every aspect as employers and as business owners. Mm-hmm. And so I've heard some buzz lately where employees who have lost childcare initially in March were covered. Everybody was shutting down and businesses were very understanding with the lack of childcare. Now, there are still businesses that are schools that are shutting down. Just recently, I'm aware of a young man who his school, it's a Christian-based school, they shut down for the last 3 days because they had a positive on corona. And so these children that would normally attend this school don't have school. The school shut down. And so you've got one parent or two parents or grandparents who have to take off to take care of these children. Mm. And employers are saying, wait a minute, we accommodated this in March. We are back in business. We are back working. You can't telework anymore. We're open for business. So there's some buzz right now about, is that discrimination where an employer might reprimand an employee for taking off time because of childcare? Is it a violation of Title VII based on sex? And there's a likelihood that we may see some discrimination charges based on coronavirus events. So that's a great question, Marty. I fully anticipate seeing that.
Yeah, you have one of those jobs where there's always something to do, and I really feel for business owners, HR staff, because there's just a lot to keep at top of the mind, and especially today and the environment that we're in. So hopefully things like this that we're having are very educational for employers. Now, what are some of the responses we can expect from the EEOC? I mean, somebody files a charge, what happens?
A good day is when you get a no cause finding that says that there was not enough evidence put forward for the EEOC to find that there was discrimination. So if you get a no cause finding, that's a good day. If you get a dismissal, that's an even better day. That says they're closing their file, they're done. There's also the opportunity for them to reach out and say, we want to conciliate. And that says, we think that there was a little bit of discrimination that maybe happened, or you just really didn't follow the law properly. And so we want you to come to the table. But conciliation means bring your checkbook. And when you get a conciliation letter from the EEOC, they will tell you how much to bring. They'll tell you, we'll settle this for $25,000. And so in my 20-year career, I've had 3 conciliations. All 3 times I've gone back to the EEOC and I've said, did you really read my position statement? Look at page 2, paragraph 5, and I would reiterate my strongest part of the argument. And 3 times I've had them come back and say, okay, we're dismissing. Unfortunately, that's not the end of it. So when they dismiss, they issue what's called a notice of right to sue. Prior to this, the employee could not file a lawsuit. This is an administrative charge. That's all it is. It's significant, but it's not a lawsuit. When they issue the notice of right to sue, that employee can now file a lawsuit. There are deadlines that they have to file that lawsuit, but that opens the litigation door. It's my experience that most people who file charges, maybe 65%, they will now go away. They've gotten their pound of flesh. They've gotten the response from the EEOC that says there's nothing here. There was no discrimination. But that's not to say that they do not have the right to sue. So you're looking at probably 2 to 3 months that they would have the ability to file a lawsuit. So it's not over when you get the dismissal.
Yeah, man, that's some great information. Like I said, you just never know what you're dealing with. You need to, make sure you're doing the things right. If they're going to put you on the spot, if there was one thing you would tell an HR person or a business owner, make sure you do this, what would that be?
That's an easy question. You gave me a softball there. Document.
Yeah.
If you document, I can't tell you how many EEOC charges that I've deferred a year period where I've had stacks of documentation and they're easy as pie. You don't have anything in the file. You don't have any handbook policies. That's when it becomes extremely difficult. So if you've got good documentation, you will more than likely prevail as long as you haven't done something that you shouldn't have done.
Yeah. Okay. Excellent. Well, Joanie, I sure do appreciate it. This was some good information. It's going to be some good information to share, no matter the time, whether we're dealing with Corona or whether this is 10 years down the road. Is some great information. So if we've got somebody in our audience that is interested in getting in touch with you, how do they do that?
It's easy. Either by telephone, that's 803-581-8190, or email. I'm always receptive to email. I'm a night owl, so even if I get emails late at night, I respond as quickly as I can. Our email is Joanie, Joanie, @Winters Law, and that's followed by S as in Sam, C as in Charlie. Can't forget that, or it'll bounce back to you. So it's winterslawsc.com.
Good deal. And the website, of course, will be winterslawsc.com. So again, appreciate you taking the time today. And to all our guests, thank you for joining us today on Leading to Win. Thank you.